The morning my wife told the hearing officer that I had spent 27 years contributing nothing of substance to our marriage, I was sitting 4 chairs down from her at the same conference table. I did not look at her when she said it. I looked at my hands, which were flat on the table, which is where I had placed them when we sat down, and I kept them there. She had prepared. You could hear it in the cadence, the pauses landing in precise places, the language just formal enough to sound credible without sounding coached. She described a marriage in which she had carried everything: the finances, the household decisions, the children's schools and doctors and college applications, the calendar that kept all of it from collapsing. She said I had been present in a physical sense, but otherwise largely unavailable. She said my career had required travel and had provided a salary that I deposited, and then, in her telling, essentially forgot about. She said the investment accounts she had grown over the past decade and the consulting practice she had built were hers, by effort and by right, because she had done that work while I was somewhere else. Her attorney, a man named Fenster who wore a watch that cost more than my first car, nodded with appropriate gravity. My attorney, a woman named Briggs who had read everything I had given her 3 times and never once blinked, wrote something on her yellow legal pad and did not slide it toward me. She didn't need to. We had already discussed what was coming. I had asked her one thing when we first met, sitting across from her with a stack of folders between us. How long would we need to wait? She had looked at the documents I spread across her desk and said, "Until they make a mistake that matters." They had. I want to tell you what 27 years of marriage looks like when it is being dismantled by the person who shared it with you. It looks small. Everything compresses. The trip to the Oregon coast the summer our daughter turned 10. The Sunday mornings I made pancakes and my son sat on the counter and talked to me about dinosaurs until the batter was ready. The 4-hour drive through a Colorado snowstorm to make it back in time for my father's birthday dinner, which my wife had organized, which I nearly missed. All of it compresses into testimony, into a characterization, into the claim that I had been present in a physical sense but otherwise largely unavailable. I was 62 years old, sitting in a conference room in Denver with my hands flat on a table, and I was doing the one thing I had spent 24 years learning to do better than almost anything else. I was waiting. She had been 31 when we met. I was 34, a fundraiser in Phoenix, the kind of event where everyone knows someone you don't, and conversation moves in short bursts between introductions. She had an energy I would describe, if I'm being precise, as purposeful. She knew people in the room I hadn't met. She introduced me to 3 of them in the first hour. I had the distinct feeling, talking to her that night, that she was always working slightly ahead of the present moment, planning for a conversation that hadn't happened yet. I found that interesting. I still do, in the way you can find a quality interesting after it has been turned against you. We were married 14 months later. Her parents came from Flagstaff. My father drove up from Tucson. My mother had passed 6 years before, and my father had figured out how to live alone in the house she had kept for 30 years, which is to say he had figured out how to survive it, which is not the same thing. The early years were the way early years are. Our daughter came in the 3rd year, our son 2 years after that. We bought a house in a suburb south of Denver with a good elementary school and a creek trail a 1/4 mile from the back gate. I traveled for work Monday through Wednesday most weeks. When I was home, I was home. Dinners, homework, weekend walks, the ordinary architecture of a family that is functioning. I was not a perfect husband. I was absent more than I should have been, and tired in ways that don't photograph well. But I was there in the ways that I knew how to be. My work. I should explain my work, because it is the part of this story that everything else hinges on. I spent 24 years as a special agent with IRS Criminal Investigation, Financial Crimes Division, trust fraud, estate manipulation, structured transactions designed to move money in directions the law did not permit. It is not work that makes for easy conversation at neighborhood cookouts, so I learned early to describe it in terms vague enough to end the subject. Government work, I would say. Auditing, sort of. Federal. People would nod and their eyes would drift toward the chip bowl, and that would be the end of it. My wife knew I worked for the federal government. She knew I carried a badge and occasionally a sidearm, though I rarely mentioned the latter. She knew I traveled and that I couldn't discuss specific cases. She accepted this without pressing, which I had initially read as respect for the nature of the work and eventually came to understand as something closer to disinterest. She was not curious about what I did the way I was curious about what she did. I have thought about that more than it probably deserves. What she did not know, specifically, was this. For the last 11 years of my career, I led the Hartley-Crane Task Force, a multi-agency investigation into a network of fraudulent trust structures that had moved approximately $40 million out of the estates of elderly Colorado residents over 9 years. The case produced 23 convictions. It was, at the time of its conclusion, the largest estate fraud prosecution in the state's history. My name appeared in the Denver Post twice, both times in the second paragraph of a long story, well below the fold. I kept those clippings in a folder I never showed anyone. I retired at 58, quietly. I told almost no one, and took on part-time consulting work for a firm that handled financial litigation. My wife described my retirement to her friends, I learned later, as me stepping back from things. That is one way to put it. She started spending time with my father about 2 years into my retirement. My father was 81. He lived alone in the house in Tucson. He and my mother had shared for 35 years. He had a pension from his years working for the state highway department, a savings account, and a trust he had established after my mother passed to insure his assets, and the house would transfer without complications when the time came. He had a vegetable garden he tended until his hips made bending difficult. He reread Louis L'Amour novels in rotation. He described himself as doing fine, and for most purposes he was. My wife began making the drive to Tucson. She said it was to help. I believed her because why wouldn't I? She would go on a Thursday, sometimes stay through Friday, help with grocery shopping, drive him to medical appointments, sit with him in the evenings. He called her one of a kind. He said it with the particular sincerity of a man who means a compliment as the highest thing he can offer. I stood in his kitchen watching them together and felt something warm. The first thing I noticed was a photograph. My father had kept a photograph on the mantle of my mother taken in 1979. She was standing in front of a truck they had owned, laughing at something off camera. That photograph had been on that mantle for over 40 years. When I visited one Sunday in October, it was gone. When I asked him about it, he looked at the mantle for a moment and said my wife had taken it for safekeeping, that the frame had been loose, that she was going to have it repaired. I nodded. The frame had not been loose the last time I visited. The second thing I noticed was a mention of paperwork. My father said, over dinner on a Sunday in December, that my wife had helped him update some estate documents. He said it the way he said most things, matter-of-factly, already processed and filed. I asked what kind of documents. He said he wasn't entirely certain, something about simplifying the language. He said she had brought someone with her, a man from her office, who had notarized it. I drove home and said nothing. I want to be precise about what happened next. I have a colleague from my years in criminal investigation who now runs an estate law practice in Colorado Springs. I called her on a Monday morning and asked, as a professional courtesy, whether she could pull the trust records for my father's estate from the county register. She called me back 2 days later. Her voice had the particular careful quality of someone who has found something they did not expect. The trust had been amended. The amendment was dated 4 months earlier. Under the revised language, my wife held co-trustee authority with broad powers of distribution for my father's care and maintenance. The scope of those powers was written, my colleague said, in language she would describe as unusually expansive for a simple elder care arrangement. The man who had notarized the document was a notary whose address matched a building 2 blocks from my wife's consulting practice. My father had early-stage cognitive decline. He had not been formally diagnosed, but I had been watching it develop for 2 years. The slowness to find words, the way he sometimes lost the thread of a conversation and picked it up 3 sentences behind where it had gone. He was not incapacitated. But he was not the man who had read every clause of his original trust document at a kitchen table with a legal dictionary and 3 different colored highlighters, asking questions until he was satisfied. I did not call my wife that evening. I did not call her the following week. I did what 24 years of investigative work had built into me the way a habit is built into a hand. I started at the perimeter and worked inward. Over the next 5 months, I pulled records through channels I still had quiet access to through my consulting work. I spoke to the branch manager at my father's bank in person, identified myself by my former credentials, which still carry weight in certain rooms, and had a conversation that answered several questions at once. I spoke to my father's original estate attorney, who had not been involved in the amendment and had not been notified it was happening. I spoke to 2 former colleagues, off the record, who helped me understand the specific legal vulnerabilities in what I was seeing. What I found, built slowly and documented without rushing. My wife had used her co-trustee authority to make 7 distributions from my father's trust accounts over 14 months, characterized in the paperwork as medical and maintenance expenses. The total was $68,000. Some of it moved into accounts I recognized. Some moved into an LLC my wife had incorporated under a name that combined our street address with a number that took me a moment to place, and then I recognized as our daughter's birthday. Beyond my father's accounts, I found that my wife's consulting practice, which she had described to the hearing officer as entirely self-built, funded by her own capital and effort, had received 3 significant transfers from our joint savings account over 4 years. Transfers I had not authorized and had not known about. The paper trail was intact. In my former profession, we called that a gift. I also found, when I looked carefully at her billing records, a pattern I recognized from 30 years of looking at patterns. Several client accounts appeared to have been billed for consulting services during periods when, based on my wife's own shared calendar, which she had never thought to remove me from, she had been traveling with our daughter or driving to Tucson to sit with my father. I am choosing my language carefully. That is a habit I will probably never shed. I did not file for divorce. My wife filed. She filed in February, and the petition described a marriage in which I had been financially disengaged, emotionally withholding, and largely dependent on her management and foresight for whatever stability we had built. She claimed her consulting practice as separate property. She claimed the investment accounts as her separate contribution. She asked for a settlement that would have left me with my car, my pension, and a fractional share of the house proceeds. Fenster had done his research on the version of me that existed in public records, a retired federal employee with a modest consulting arrangement and a government pension. That version of me was a reasonable target for the case he was constructing. Briggs read everything I brought her in one sitting. When she finished, she was quiet for a moment, and then she said, "This is an unusual amount of documentation for someone who reportedly had no financial awareness." I said I'd had time to be thorough. She said, "I need to understand one thing. You had all of this before she filed." I said, "Yes." She said, "And you waited for her to move first." I said, "It tends to be cleaner when the other party initiates. The posture of the proceeding shifts." She looked at me over her reading glasses for a long moment. Then she said, "How patient can you be in that room when she's speaking?" I told her I had once sat stationary surveillance for 11 hours in January outside a storage facility in Pueblo, in a car with a broken heater. She almost smiled. "All right," she said, "then we wait." Sitting in that conference room in February, listening to my wife explain that I had minimal financial engagement throughout our marriage and had trusted her completely with all decision-making, I thought about what it costs to stay still while something false is being said about you, in a room where false things, once spoken into the record, have weight. My jaw was tight. I kept my hands flat and breathed through it. Her attorney was smooth. My career was described as steady but unremarkable. My retirement was framed as a withdrawal from responsibility. The characterization was persuasive in the way a well-built assumption is persuasive before someone looks at it from an angle it wasn't designed to withstand. The hearing officer was a retired judge named Ketterman, who had been appointed to this role through the county mediation program. He had the particular unhurried quality of someone who had spent decades listening to people present the version of events that served them best, and had stopped being in any hurry to respond. He let my wife finish. He let Fenster add his framing. Then he opened the folder Briggs had submitted that morning and read quietly for a long time. When he looked up, he looked at Fenster. "Counselor," he said, "you've characterized your client's husband as someone without meaningful financial sophistication who deferred to your client on all matters of consequence." Fenster said that was correct. Ketterman held up a document. "Are you familiar with a case called Hartley-Crane?" The room shifted, not loudly, the way a room shifts when something enters it that no one was expecting. Fenster said he wasn't certain he was. Ketterman set the page down with the deliberate care of a man who is not in a hurry. Hartley-Crane was a multi-agency estate fraud prosecution finalized in 2013. $40 million recovered. 23 convictions. It was the largest estate fraud case in this state's history. He looked at Fenster steadily. The lead investigator was a special agent with IRS criminal investigation. He retired from that division after 24 years of service. Another pause. "I am looking at his retirement commendation, which is in the file opposing counsel submitted this morning." He looked at me. I held his gaze and said nothing. Then he looked at my wife. She was looking at me. It was the first time in the entire hearing she had looked at me directly. Her expression was one I had seen before, not on her face but on other faces, in other rooms, at other tables over the years. The particular expression of someone whose understanding of the ground beneath them has shifted without warning, and who is only now registering the distance of the fall. Ketterman folded his hands on the table. Your client has testified that her husband had no meaningful financial awareness and left all decision-making to her. She also, based on these documents, holds co-trustee authority over his elderly father's accounts and has been the primary manager of a business entity that received funds from their joint savings. He let that settle. Given what I'm now looking at regarding this man's professional background and the documentation opposing counsel has provided, I have significant questions about how this marriage's finances were actually structured. And I have concerns that go beyond the scope of a standard dissolution proceeding. He looked at Fenster one more time. I'm calling a recess. I would strongly suggest you and your client use it to reassess the direction of this hearing. Fenster leaned toward my wife immediately, his voice dropping. I did not look at her. Looking at her in that moment felt like something I did not want to do and did not need to. In the hallway, Briggs bought 2 cups of coffee from the machine near the elevator and handed me one without speaking. After a moment, she said, "Ketterman will refer the trust documents. That moves separately from the divorce." I said I understood. She looked at me. "You knew when you let her file that this is where it would go." I said I had believed it would. She nodded once. "You've done this kind of thing before." I said I had spent a long time understanding how these processes move and where pressure finds its natural outlet. She finished her coffee. We went back inside. When we returned, Fenster requested a continuance. Ketterman granted it and made clear, in language that was precise without being theatrical, that the financial documentation in the record would be reviewed by parties with broader authority than a divorce mediator. He said this looking at Fenster, not at my wife, which told me he had a clear picture of exactly what had happened and was extending one professional courtesy before the process moved to its next phase. My wife left the building without looking at me. I stood at the top of the front steps and watched her and her attorney walk toward the parking structure across the street. She walked with her head angled slightly down, moving quickly. 27 years, and that was how she walked away from me, head down, moving fast. I called my father from the parking lot. He answered on the 3rd ring, which was a little slower than usual. I told him the hearing had gone well. He said he was glad. He asked if I was coming Sunday. I said I was. He said he had picked up a ham. I told him I loved him and I'd see him Sunday, and I hung up. My son called 2 nights later. He had spoken to his mother. He was careful in the way he has always been careful when he believes he is standing in the middle of something, which meant he was troubled and trying not to show how troubled. He said he was trying to understand what had happened. I told him I would explain everything when the full picture was available. He said that wasn't good enough. I said I understood that. A long silence. Then he said he needed some time. I told him to take what he needed. My daughter called the following week. She cried on the phone without apologizing for it, which is how she has always handled things that overwhelm her. Directly, without ceremony. She said she had found out about the trust documents. She had confronted her mother. The conversation had not resolved the way she hoped. She asked me why I hadn't told her what was happening while it was happening. I said because I had wanted to be able to show her, not just tell her. There is a difference. She was quiet. Then she said, "Dad, how did you know she would be the one to file?" I said I hadn't known with certainty. I had made a reasonable bet based on how I understood her to think. She had always moved toward control of the situation. Filing first looked like control. My daughter said, "That's very cold." I said maybe. Or maybe it was just the clearest path I knew to protect what needed protecting. She cried a little more and I stayed on the phone and let her. 6 weeks after the hearing, Fenster contacted Briggs with a settlement offer that bore almost no resemblance to the original petition. The investment accounts were no longer disputed. The house was no longer disputed. My pension was no longer disputed. There was a provision for full repayment to my father's trust from my wife's personal and business assets, structured across 3 years. There was a separate provision regarding the consulting practice's financial records, the handling of which Briggs described to me as something that would not go away quietly, but also would not need a trial. I signed the papers on a Tuesday in April. The county referred the trust amendment to the Elder Fraud Unit. That process moved on its own timeline, in its own way, as those processes do. I gave them everything I had documented, all of it organized and indexed the way I had organized and indexed evidence for 2.5 decades, and then I stepped back. That is not my role anymore. It was not always easy to step back. There is a version of me, the one who spent years seeing what other people missed, that would have preferred to stay in the room. But there is a difference between doing a job and being unable to put it down, and I spent 24 years coming to understand that distinction from both sides. My son came to the house in May. We sat at the kitchen table and I made coffee, and we didn't talk about his mother for the first hour. We talked about his work, which he does well, and about his kids, who are 4 and 7, and who I do not see nearly enough. At some point, he set his mug down, looked at the table, and said he should have asked more questions over the years. About me. About all of it. I said he had been living his own life, which was what he was supposed to be doing. He said that felt like an excuse. I said it wasn't one, it was just what happens. Children grow up and stop asking their parents to explain themselves, and parents let them, because that's how it's supposed to go. He nodded in the way he has always nodded when he is absorbing something he doesn't fully accept yet, but isn't ready to push back on. He'll get there in his own time, he always does. My daughter came in June with her husband and their dog. She and I walked the creek trail behind the house while her husband read on the back porch. She held my arm the way she did when she was small. She didn't say much. At the turnaround point, she stopped and looked at the water moving over the stones and said, "I keep thinking about Grandpa. What could have happened if you hadn't found it when you did?" I said I knew. She said, "You sat on this for 5 months. You knew and you didn't say a word to anyone." I said that was right. She said, "How does a person do that?" I said you learn to hold things quietly when your entire career has been built on the understanding that what you do with what you know matters more than how fast you move. Timing is not patience for its own sake. It is patience for a reason. She looked at me for a long moment. Then she said, "I think I'm only now beginning to understand what you did for all those years, what you actually did." I didn't say anything to that. I just started walking back toward the house. My father's photograph came back. It arrived in a shipping box, part of the property settlement delivered by courier. The frame was undamaged. It had never been loose. I drove it down to Tucson the following Sunday and put it back on the mantel, and my father looked at it for a moment the way he looks at things when he is placing them back in the order of things, and then he looked at me and said, "I wondered where that got to." I said it had taken a wrong turn, but it was home now. I am 62 years old. I live in the house where my children grew up, and the quiet of it is something I am still learning to inhabit. Not badly, just differently. I walk in the morning along the creek trail. I cook more than I used to, which my son says surprises him, and my daughter says doesn't surprise her at all. I consult 2 days a week for a litigation firm that gives me interesting problems and respects that I do not need to be managed. That combination is rarer than it sounds. I think sometimes about what Ketterman said in that room, not the referral or the legal mechanics of what followed. Just the moment before, the moment when he looked up from that folder and asked Fenster whether he knew the Hartley-Crane case. The work I had been most proud of in my career, the work I had never framed on a wall or explained at dinner, suddenly in the room. Named by someone who had actually read the file. My wife had constructed her entire case on a single premise, that a man who says very little about himself must not have much to say, that a husband who steps back from arguments must be someone who loses them. That silence extended over years means absence. She was wrong about that. She was wrong about several things, but most wrong about that. Silence is not the same as absence. I know the difference between a man who has nothing and a man who is simply waiting for the right room and the right moment to show what he has been holding. I spent 24 years building that knowledge, conversation by conversation, document by document, in parking lots in January and conference rooms on Tuesday mornings in February. I do not say I told you so. I never do. It is not in my nature and it does not serve any purpose I can identify. I just drove home the afternoon the papers were signed, changed out of the suit I'd worn to the final appointment, and put on the coffee. Some things, when they're finished, don't need a word added to them.